That's right. It's unascertained goods. So they decided on the basis of when you go into the shops, if you go to the shops and you go in and you say, I'm going to buy a pound of potatoes, and I'll collect them later, you can go in and buy ascertained goods. You can pick the potatoes, pick out your potatoes yourself, put them in a container and give them and say, these are the pound of the potatoes I'm buying. Or you can buy what are called unascertained goods. You can go to say, I want a pound of potatoes and I'll collect them later. In which case, of a big pool of potatoes, the shop owner will pick out at some stage, you know. So in Goldcorp, it was that sort of thing. What was the nature of what had been entered into? Even though the investors, I think, had been led to believe that they were getting sort of a trust interest. In fact, the documentation indicated that what they were buying was an unascertained good. So it was a right to have a certain amount of gold delivered to them within a certain period. So why they might have believed that they were buying particular blocks of gold, all they contracted for was a right to have that gold delivered to them on 10 days' notice. So it was, and that was treated as insufficient. Yeah.
Wasn't the gold stored?
Yes.
With the companies trading gold?
Yes, I think there was. It was all a big mix, and in fact, for the number of investors, there wasn't enough gold, left in the stores even to fulfill the people that had invested in there.
So there was gold held on trust and gold held for trading, and it was all together.
All together.
The trust stuff wasn't even set aside.
No, it wasn't set aside, and there were also coins. So there was some. I think it might have been some assets of what was the old was Walker and Hall.
Yeah.
They were decided that there was a trust interest in relation to that had been validly set up. But I'm trying to remember, for some reason I don't think they got it. I can't remember the facts. But the main problem with that case was the nature of the contractual obligation. They contracted to buy unascertained goods. So it was just a contractual right. And so they couldn't point to any asset. But I think you're absolutely right. If you have gold ingots, it's intangible, tangible doesn't work. It should be looking at, is one thing indistinguishable from the other?
It's interesting in terms of internet trading nowadays, isn't it, as to what you're actually entering into.
Yeah. Oh, look, that's why this has come up in the Lehman Brothers. And some really interesting things that they were doing internally and the courts had to work out whether is this a trust relationship or not. Yeah, you get all sorts of.
Yeah.
Don't want to get into blockchain, that gets even more complicated. Okay. So, I'm not sure I have this thing. So, okay. So, that's all I really want to say about certainty of subject matter, just so that you understand that there are rules that you need to comply with. Okay? So, the third thing you need in order to create a valid trust is something called certainty of objects. Now, we do, as I say at the start, we do have this rule in English law called the beneficiary principle, and it comes from this case, it's from 1805 or 1804 or 1805, Morris and the Bishop of Durham, which says that express trusts, private trusts, must exist for the benefit of people, not purposes. Charitable trusts can be for purposes, express trusts can't. Apart from, just so you know, because it's interesting, there's a little pocket of cases where purpose trusts are actually recognised as being legitimate, and they are, but they're very, very small little pocket of cases, and they are trusts that were set up for the preservation or sort of for looking after monuments and graves. Yeah, all those things, and actually, some trusts for pets, yeah, and in fact, an extraordinarily large amount of money is left to pets in England every year under trusts, including where I lived in London. A house was left for a cat, in a suburban street in a leafy suburb of London, there was a house left for the cat, but they're trusts of imperfect obligation, because they are only recognised as a valid trust. An animal is a chattel, so that's the same as having a purpose trust, but they're only recognised if the trustee is prepared to carry them out. Because the problem with them, the reason why we have the beneficiary principle, is because the courts say you've got to be able to point to a person who can enforce the trust against the trustee. Now, with charitable trusts, the Attorney General has the obligation to sue trustees of charitable trusts if things go wrong. With express trusts, the only you've got to be able to hold the trustee accountable, and the only person available for that would be a physical, a beneficiary, a person, legal or, a human person. So, and that still exists. There are some cases on the margins which appear to be purpose trusts. There's one case we won't go into. So there's some cases on the margin. There's one, Reed Denley, but which didn't amount. It's normally things that didn't amount to a charitable trust, but was for, I think it was to do with some sort of holiday camp. Okay. But so the rules we actually use are still the rules for people. So what we say is that when you're looking at whether you have got a valid trust, there are two concepts that are referred to. One is conceptual certainty we'll do first. The idea is when you are describing a pool or a class of beneficiaries, you've got to use a word that has a clear definition, so that you can tell who's in the pool. So words like children, cousins are fine, because we all, you can work out who's the child through DNA testing. You can work out who are cousins. Words that aren't certain enough would be things like old friends, and also I've put this in there because there is a case about it, a pure-blooded Englishman. Well, there aren't any. England is a country of immigrants. For thousands, for as long as its existence, just wave and wave of immigration. So they're a very mixed bunch. So it doesn't work. They said you can't describe it because there aren't any. So you've got to use words that are conceptually certain to describe your class, but you also need evidential certainty. Now, when you see this discussed, it does seem quite weird, because they talk about it being the extent to which evidence is available in a particular class, a case, to prove an individual is a member of the class. So I think what you can take that as meaning is that is there going to be any evidence that can prove that somebody's a member of a class? So, an example of that might be if you could have conceptual certainty for a word. You could say, I leave all my assets to aliens. Now that's certain. So you'd say, well, aliens means anybody who doesn't live on Earth or comes from a foreign, legal system. But of course, that would have no evidential certainty, because we don't know whether they exist or not. Yeah. So that's part of what that sort of is. But when you're looking at evidential certainty, you can also look at it as, can you prove that you're a member of that class? So it's a bit of a confused sort of phrase. But when we're looking at what sort of certainty you need, the test differs depending on what sort of trust you've got. So if you've got a fixed trust where you've got beneficiaries who've got definite interests, your test for certainty of who the beneficiaries are must fulfil something called the complete list test, and that means it's got to be conceptually certain and evidentially certain. So effectively what you're supposed to be able to do is create a list of who the people are. And that makes sense, because your beneficiaries, if you're saying to the trustee, you have no discretion, you simply must do what is right for this person and that person, and if you do anything else, you're in breach. Well, you've got to enable them to know who the people are. Okay, so when you come down to discretionary trusts, the test is more fluid. And it's more fluid because, in this case, the risk on the trustees of getting it wrong, they don't have to give a specific asset to a specific person. They have a discretion, and they can give what they want. So they're not tied to a particular asset. They can choose what to give. What they do need to know is who the beneficiaries are. So in that case, the test we use is this test from McPhail and Dalton, and it's referred to often as the any given postulant test, or the in and out test, or sometimes it's referred to as the is or is not test. And it only requires conceptual certainty. So words that define the class accurately. And the test is basically, you must be able to say with certainty, that any given individual is or is not a member of the class. Any given individual is or is not a member of the class. Now, just to give you the bit of background to this test, there was a test for powers in Regal Benkian. So for certainty, you need to have certainty for powers. When you give somebody a power, you want to know who you've given the power to, what the power is, and what the power's over. So you have rules for that as well. But they took this test from Regal Benkian, which is powers, and applied it to discretionary trusts, which are obviously a combination of powers of appointment and trusts. But the case is quite interesting that it came from. It came from basically the assets, or the whole thing's about the assets of a man called Bertram Baden, who was chairman and managing director of Matthew Hall, which was a large engineering company. He made an absolute fortune. It still exists, taken over by Spee, the German company. So he made his will, and what he did was he decided that, because he was very, very wealthy, that he actually wanted some of the assets, to go to his employees and ex-employees. So he made his will, and the clause that attempted to create the trust obligation referred to employees, ex-employees, and their relatives and dependents. Now, once he died, his own relatives challenged the will, and they in particular challenged the creation of that trust. They said it doesn't create a trust. So the first argument that went to the court, and it went right up to the House of Lords, was McPhail and Dalton, and that was to say, what is the nature of the obligation? Is it a discretionary trust? Does it actually amount to a trust or not? Or is it simply a power? And the House of Lords said this is a discretionary trust. And then the case was then remitted down, and they said, so it's a discretionary trust, and the test for working out whether the trust is valid, for the words that are used for the potential beneficiaries, is the is not test, or the any given postulant test from Regal Benkian. So that was determined in McPhail and Dalton, and then the case was remitted down to the High Court for the High Court to apply the test, and that case was renamed Re Baden's Deed Trust, and so the High Court attempted to apply the test, and then that was challenged, and the case went up to the Court of Appeal. Now, all I'm going to say about this test is it's really unsatisfying for lawyers because it's fuzzy. We like things to be, if you're going to apply a test, you want to know, apply the test, get this answer. If it applies this way, it works this way. This test is malleable. And in fact, all three judges in the Court of Appeal came up with a different meaning as to what it, basically what it meant. So just to go through it with you. So the test is, can you say with certainty that any given individual is or is not a member of the class? So when it came to the Court of Appeal applying that, they had to use, now they were fine with the words employees, they were fine with the words ex-employees, I think they might have been fine with dependents, but the problem was relatives. Who is a relative? We in New Zealand have a very broad, I would say we have a broad definition of relatives, and actually it's only got to a limited extent does it depend on blood, and being linked by family. We have, bigger families, don't we really? Okay, so when they came to determine what relatives meant, they all decided it was certain, but they decided for different reasons. So Sachs, and actually Magor, said relatives means all descendants of a common ancestor. Now at the time, DNA testing was limited. But in fact, if you think about the meaning of relatives, if you applied that now, because I think we are all descended, aren't we, from... I don't get this, but anyway, isn't it? I don't know the numbers anymore, but I think it was originally 5 women and 3 men, originally, because following mitochondrial DNA and But so anyway, but at the time, that's what they said. It means all descendants of a common ancestor. So, so that means that your pool could actually be quite big. Anybody descended, so you'd have to show some blood link. Stamp said, no, that's too broad. And he said it means next of kin. So normally your next of kin will be one other person or maybe a couple. Yeah? So but next of kin means your nearest living relative. So he would treat it quite narrowly. And then Sachs said, okay, so work out, are you are you a descendant? Are you descended from a common ancestor? And then, can you prove that you are? And if you can prove you're in, if you can't prove you're out. So that would mean that you'd say, I'm descended from Auntie Jo, I don't know, from my great-great-grandmother, and then you'd prove it by showing birth certificates and marriage certificates and or whatever what you could, So you'd have some sort of proof. Or the Habsburg jaw, I don't know, you all had to... So he said that. Magor said, well, he just treated it in a very fuzzy way. He said, oh, well, the class is certain if you can say of a substantial number of people that they're within it. He said, and basically said if there's more than one. If the class is only one, it's not valid, but if it's more, we don't say how much more, but if it's more, it's fine.
Did they get any sort of decision?
No, I know. Just, that's why it's very unsatisfying, but it is the test. We use this test. Anyway, and the last one was, so he stamped it very narrowly, and he said exactly what the words of the test are. Can you prove you're in or out? So he said you must be able to say definitely if someone is in or if someone is out of the class. But that's okay because he could do that because he narrowed the pool so narrowly. So we have this test that is largely unsatisfying. It does let in more people than the list test, so that's good. But just think it's motivated by the fact that you had, in the Baden case, these relatives who wanted to flee. Well, no, they wanted to get the money instead of their employees. And the courts, if you think about it, are bending over backwards to try and protect that, the rights of the employees. So if you get in a question from me, is the word relatives certain? Yes, it is, because Re Baden says it is. But there's all sorts of other words that, if I'm testing something, I can stick in. So I might say something like, if I use the words old friends, you'd easily argue that that's not, who's a friend. And in fact, I wish I could find the case, I did read it years ago, about friends. There's a quip by a superior judge, an English judge, a House of Lords judge, who said, who said something like, very hard to tell who your friends are. Basically, I've been working with all these judges, House of Lords judges, we sit in morning tea, have tea, but I wouldn't call any of them my friend, Yeah. Yeah. So, something like old friends, there actually is a case, Re Barlow, I think, that sort of indicates that it's not certain, but it wouldn't be, because who's a friend? But if I use something like acquaintances, is that certain? Well, yeah. Yes. So you could say, you've got to think conceptual certainty. Is it, you could say, an acquaintance is anybody I've ever met? Yeah. You might, or and some people never forget a face. So some people do.
Cast it so wide?
Yeah.
Yes. And that's exactly what the courts have said. In this case, District Auditor, West Metropolitan City Council, a trust for the benefit of any or all or some of the inhabitants of West Yorkshire was invalid because it was just too big. So you get administrative unworkability. And there were 2.5 million inhabitants. So the courts will just say if it's too big, ignore it. Now, what happens if you've got a lack of one of these certainties? It depends slightly on the situation. But usually if you've got a lack of intention, no certainty of intention, so you don't know, somebody said, I give to X, and you attach words to it, if it fails, normally what will happen is it will take effect as an absolute gift. Or sometimes, it just depends on the situation, sometimes it'll take, if it's made clear that whatever has been created, the person you've named isn't supposed to get any benefit at all, but you just don't know what actually has happened, then there would be a resulting trust back to the settlor. If it's made clear that, I give to A to do something, that a gift wasn't intended, then a resulting trust back to the settlor. If you have a lack of subject matter, so there's no subject matter for the trust, then sometimes we would say that the trust is void and has never been created. because you've actually got to know what the assets are. But that's different from, the situation I described where you have transfer of legal title and the trustees are holding legal title to an asset. Clearly, that's a situation where all you've got is a lack of information about who exactly the objects are. And if you have that problem, then the asset will be held on resulting trust. Yeah? So between the rules, normally what will happen is either nothing or a resulting trust will be used to fix up the situation so that the equitable title rests with somebody and is never left to just float around in the ether. Okay, now the next, we can do two things. We can have some lunch now, quickly, or I can carry on, because you've got to go at 1. Should we carry on for half an hour and I'll just do another? Yeah, you just carry on and we'll stop at 1. They are up.
Oh,
Yep, yeah, they're up. So I'm sort of racing through this a bit. Okay, so let's start and have a look at formalities before we do constitution. What's that one? Oh, actually, we'll do constitution. Formalities a bit easier, so we'll do constitution first. So the idea here is that in order to create your entity, your trust, or to do whatever you're doing, you have to actually part with ownership of the asset, and ownership has to go. Legal ownership has to go to the trustee for the benefit of the beneficiary. But the same thing happens when you're giving a gift. If I'm giving you a gift, there's a legal test for the valid creation of a gift. And there will be an absolute point in time at which the common law recognises that title to the gift passes from the giver to the receiver. So and how that happens depends on what you're giving. So if I take a chattel like a pen, and I say to you, I'm giving this to you, and I hand it over, then the minute I hand it over to you, I might say the words and then give it to you, that's fine. That gift is perfected. I might give it to you and then say the words. But what you need is a combination of two things. You need to have an intention to give, and then you have to have transfer of legal title to the asset according to whatever the asset is. So if it's a chattel, title will pass on possession. Same thing with money. That's why we use it. Title passes on possession. But if it's land, then I've got to comply with, if I transfer legal title to you, I've got to comply with the test for transferring land, which is to register you as the legal owner. The same with shares. I've got to follow the procedures in the CUP section, was it 89 it's two sections, 89, it might be 94 of the Companies Act. Yeah? So you need to have those two things combined. Sometimes equity will recognise that equitable as title has passed, even though legal title hasn't. Anybody example? No. Well, actually, one example of where you can see a difference between where equitable title is recognised as passing before legal is when you've got a sale and purchase agreement, isn't it? Of land.
Oh, right.
Yeah. You get it. And that's because that is a strictly enforceable in contract. You get specific performance. If the seller and purchaser of land, if the seller won't proceed, the purchaser has got an equitable remedy of specific performance. They can force the contract through because land is treated as something unique. But how that works is by the court saying, well, on the contract being valid contract being created, the purchaser is treated as the equitable owner. So we do have situations in time where, although the common law won't treat title as having passed, legal title as having passed, the courts will treat equitable title as having passed. Yeah?
Because part of that gift is also the test. You've got to do everything that you are obligated to do. I think that came from a case where they gave it to an agent to deliver, and the agent never delivered it.
Yeah,
Well,
yeah.
you can deliver it. there's nothing else that you could have done to deliver it.
Yes, no, that's right. That's right. That's right. That's right. And we'll look at some of those.
Those exemptions, yeah.
Yeah, no, there are exceptions to it. Part performance, estoppels, and equity has other ways around, because you can see that a lot of injustice can arise if you must follow only the common law rules and something happens to stop it. The computer crashes just as the title is supposed to go through.
Or if it's yours,
Yeah.
come and collect it.
Yes. Yeah, and then you haven't collected. Well, yeah.
Yeah, so it throws up all sorts of.
Yes. Yeah, well, that's right. Well, and it's very easy for me to stick something in. That sort of thing. Okay, so if you want to perfect a gift, you have to follow the common law rules of gifting. Intention to give plus transfer of legal title, depending on the nature of the actual asset you've got. The same sort of thing operates with a trust. If you've got to validly constitute your trust, that means transfer your legal title to your trustee. All these methods are discussed in a famous case called Milroy and Lord. Okay, so in Milroy and Lord, basically the court said, well, there are three basic methods of ridding yourself of ownership of something. You can create an outright gift. For that, you need intention to give and transfer of title. If you do that, that's fine. You can create a transfer on trust. So declare a trust with a third person as the trustee. And to do that, you need a valid declaration of trust, complying with your three certainties. And you've got to make it, so certainty of intention, what is the asset, who's it going to? And then you need to transfer legal title to your trustee. And they said, but you can also self-declare a trust. And that's the easiest thing to do because you don't need to constitute the trust. Because if you self-declare a trust, you're already the legal owner of the asset, and all you're doing is saying, I'll retain legal title, but I no longer have the equitable title. Okay, so if you want to declare a trust, self-declare a trust, you declare the trust with yourself as the original owner, so you've got to, all you need there is a valid declaration.
So you could have a person who was the settlor and make himself the only trustee, and he could have valid trustees provided he had more than himself as beneficiary. So there was himself and whoever else decided to nominate. So that's a self-declaration.
Yeah, self-declaration, yeah. And you don't need to constitute the trust because you've already got, if you're the only sole trustee. If you have other trustees, you're supposed to constitute the trust, although there is a case called Choitram and Pagarani, which if we get time we'll go through, where that was again a case of a very wealthy man who had set up a chain of, they're still there, a chain of supermarkets in Sierra Leone and made millions and millions. Very generous, gave a lot of money away during his lifetime, but he had a complicated family situation. He was Hindu, Indian, and he had one family in India and another family in Sierra Leone, and there was a big scrap. I mean, he wanted to give away, he took care of his family and then wanted to leave everything on trust. It's quite, part of the, I think, Hindu religion, often they've these obligations of, he was very generous anyway, gave to charity. And there was a fight because his gifting wasn't formalised at the moment he had died, but it was a partial self-declaration. So you do get, things that are slightly more complicated. Okay, so where you are looking to benefit others, it's basically in order to work out whether you've done what you need to do properly, you need to think about three things. First of all, you need to understand the nature of the asset, and particularly you need to know, is this something where there is a legal title, so it's a common law title has been given away, or is it first of all, you need to know the nature of the asset, so you need to know how you do it, land, chattel, or whatever. Then you need to know the nature of the asset. Is it legal or equitable? Because if I'm creating a trust of an equitable interest, if I've got a life interest under a trust, I have got something that is equitable in property. It's a property interest recognised in equity, and I can actually give that away. It's of value because it's treated as property. I can give it away. I could give it away to my child, and I could say, I've got a life interest in this house. I don't need to live there because I can live somewhere else. I'm gifting it to you, and then they get a life interest in a house, but it doesn't change the life interest. It's still a life interest on my life, but I can just give it to them. So there's no need to transfer legal title in that case because I'm only giving away an equitable interest. Yeah? So you've got to look at what actually is being given away and how are you supposed to do it, and it'll depend on what the nature of the asset is. Is it, and then the third thing is you've got to work out exactly what you're doing. Are you outright gifting? Are you creating a transfer on trust? Or are you creating a self-declaration? And typically they're referred to as method 1, method 2, or method 3 from Milroy, because that's where it was set out. So method 1 is gift, method 2, transfer on trust, method 3, self-declaration. Now, there are maxims that operate to guide the courts on whether, as to whether things will be treated as have being done completely in law. And the first maxim that equity operates is that equity will not assist a volunteer. So the normal rule that equity says is that they treat people who are purchasers and volunteers differently. So if you're a purchaser of something, so you've given consideration and something goes wrong, equity will sometimes step in and help. Like with, sale and purchase agreements for land. They will say, we've got a special remedy for you. If somebody tries to renege on selling you land, this would normally be a contract where you can have specific performance and force the bargain. But they treat volunteers differently. And the basic rule they say is, well, if you're a volunteer, you're not given consideration, our main position is we're not going to help you. Yeah? So equity will not assist a volunteer. And equity will not perfect an imperfect gift. So if I say to you, I'm giving you everything I own, I give you everything I own, yeah? But I haven't delivered anything to you, so I haven't fulfilled the rule. You can't legally enforce my words. I give you everything I own because I haven't done everything I'm supposed to do, and equity won't help you, which is, so the basic rule is fair enough, I think. Looks quite well. Now, the next thing that maxim that operates under Milroy in relation to constitution of a trust is that the position equity takes is equity will not assist a volunteer by treating a failed gift or transfer on trust where you need to constitute it and transfer legal title as a self-declaration. Okay, so just to explain that, if I'm intending to gift something to you or create a trust with somebody else as the trustee, we'll do a gift first. If I'm intending to gift something to you, and I fail to complete that at law because I don't transfer legal title, one way equity could fix that was treat my words I give to you as being words of self-declaration of trust. Because if they treat them as not a gift but as a self-declaration, there doesn't need to be any constitution, and it would fix the problem of me not having transferred legal title. So instead of the words treating the courts saying the words I give mean I give, they can say, well, the words I give mean I give on trust. And then you get the beneficial interest. But the position, so gifts could be fixed if you did that, but also failed transfers on trust could be. So if I said, I give my assets on trust, Simon Wheel is the trustee, and I never transfer legal title to Simon, then again you could fix that if you treat my words, I give on trust, as being me being the trustee. So just you haven't given it to Simon, but you've got it, and so it would fix everything. But equity says, well, we're not prepared to do that. If somebody says, I intend to give this to you, and for some reason it isn't, legal title isn't transferred, the first position equity takes is to say it's failed. We're not going to help. Yeah? And that is because if I'm giving it away, what I am not intending is that I will be a trustee. I'm intending to rid myself of it and do nothing. If the courts treat it as a self-declaration, then that whole multifarious bundle of obligations that trustees are under fall on my shoulders. And the courts say, you never intended to that, you weren't saying you were going to do that, so we won't treat it as that. Okay. Now, there are a whole lot of cases which seem quite harsh where there have been failed gifts, but that's what we work with. So if you look at Cousins, actually, we'll go on to the next. Yeah, we'll just do these three. They're logical. So if you look at Richards and Delbridge, that was a case where I think it was a grandfather, owned the lease to a mill. And these things tend to, they good businesses, you could generate a lot of money. And the holder of the lease decided that he wanted to give it to his grandson, Edward. So what he did was he wrote on the back of the lease and signed it. So he wrote a memorandum saying that he was giving the lease to his grandson, Edward, and he signed it. And then he delivered the lease, the lease document, to Edward's mother. Edward was a minor. And then he died. So the issue was that a valid gift of that lease over that mill? Now, in order to, there was a way that you were supposed to transfer leases, and the writing of a memorandum on the lease document was not sufficient in law. You probably needed some sort of assignment by deed. I think you had to do it by deed, transfer by deed. And that hadn't been done, so it was treated as a failed gift. Edward did not get the lease of the mill. The lease of the mill just fell into the estate of the grandfather and was passed out to the beneficiaries under the will. So it was a failed lifetime gift. Now, the same is true of this case, Jones and Locke. This is quite an odd case, I think, of its time. Mr. Jones was an ironmonger, and he clearly wasn't happily married. He spent a lot of time working, and the case says that he came back from a job and he was holding a cheque for £900, which is a lot of money then. And his wife had a young baby, and the case says that she chided him. So it tells you how old it is, chided him, yeah. And for not bringing anything back for the baby. So he just said, the baby can have this, cheque for £900, and then he died. Not quite immediately on the spot, but very shortly after. So the issue was, who owns the cheque for $900? Was it validly given to the baby, or does it fall into his estate? Well, there is a way in which you can transfer cheques. Yeah. So normally, when the rules have changed a lot. They used to be negotiable instruments, so you could use them in a bit like cash. Yeah. And the way you did that was to make it negotiable. You signed the back, didn't you? So if you gave me a cheque, it was not stamped, not negotiable. So it was a negotiable instrument. And I'm the recipient. I sign the back, and I can give it to somebody else. So that was the way to transfer title to that cheque at that particular time. The father didn't do it, so the baby didn't get the money. Yeah. Now, the same is true of Milroy and Lord. So those are two failed gift cases. Milroy and Lord is a failed trust case. In this case, the asset was shares in a Louisiana bank. And in that case, there was a man called Thomas Medley, and he executed a deed purporting to transfer some shares in this bank to somebody called Samuel Lord on trust for the Milroys. So he executed a deed purporting to transfer 50 shares in this bank to Mr. Lord on trust for the plaintiffs. What he was supposed to do was then record the ownership of the shares, so it had to be recorded in the books of the bank to show the change of shareholding, and that was never done. So when Thomas Medley died, he was still recorded in the books of the company as being the owner. So the issue was this a valid trust or not? And in fact, before he died, he believed that a valid trust had been set up, and the beneficiaries, actually, the Milroys, received dividends from these shares. But no, he died, and everything went to equity. And, he had to work out what was in his estate and what wasn't. So these shares were recorded in his name. So the courts had to say, was a valid trust created? And the court said, no, a valid trust was not created because legal title to these shares needed to be transferred into the name of the trustees to Mr. Lord. That was never done. No trust. Okay. So you can have a failed gift or a failed estate. We have a similar situation in New Zealand. And this is slightly similar. In this case, you had an uncle who wanted to gift some land to a nephew. Yeah, that's right. But the uncle died before that action was taken place. So what the uncle had done was he'd given a memorandum of transfer to a solicitor who acted for both the uncle and the nephew. Now, the solicitor already held the certificate of title, but he said that he was holding it for the uncle. That's what his instructions were, that the certificate of title he was holding for the uncle, but the memorandum of transfer that you needed at that time, he was holding for both. So when the uncle died, the nephew didn't have all the documentation needed to transfer the land, and so the courts had to just basically looked at the situation and said, well, if the uncle had delivered both the memorandum of transfer and the certificate of title to the lawyer and said, these are for my nephew, equity would have perfected the gift. But since the nephew only had one of the relevant documents and didn't have the, certificate of title wasn't held for the nephew, it was a failed gift.